my lord, can't assure what would happen in the on the floor of the house.
That's right.
Whether it would be passed, it would be.
No, that
And
that
then
majorities are there. We are all in support of.
No, not it would be. I'm sorry, my lord, my learned friend.
The bill itself.
No, my learned friend took it, my lord, purposefully wrongly. I didn't say.
Your Lordship's judgment will stand in the way, my lords, of the bill that has already been passed.
It might, the parliament may be benefited of the judicial view on this.
The problem
The
there,
parliament-
I'm sorry to say that the problem there is,
We don't go into discussion over the bill.
no, but
but
necessarily,
issues
my
will-
lords,
issues
issues
will
are
be-
exactly the same.
And
Issues
the
with-
irony is,
Privacy, consent, they're all the same.
my lord, irony is, as I said yesterday, I'm supporting the users. Sorry,
Whatever is coming.
hey, whatever you are doing in other countries,
Yes.
you cannot discriminate India. That's, my lord, the stand of the.
My lord, hold on. My lord, that's one. There are two global.
From what transpired yesterday, what Mr. Diwan was telling, there were attempts, earlier bills were placed, but it didn't work through. Today, of course, we have the Attorney General also, along with the Solicitor General. So, what he was saying is, there is many a slip between the cup and the lip. Just because a bill is proposed to be presented before the Parliament, it could go before a committee for deliberations. So in near future, it may not be forthcoming. So that is the anxiety expressed from the other side. And we take it that what Mr. Mehta told yesterday, the same is the stand of the Attorney General.
Yes,
If
yes.
the Attorney General would apprise us of the timeline within which you reasonably expect that an act is coming into force, then there could be a reason for us to sort of say that, all right, we don't sort of proceed with the hearing, but otherwise,
Can say.
there's an element of uncertainty because you are asking for comments from the public and you are saying that you are proposing to present the bill. Now, what happens? We know legislative process it has its own ways of going away.
That's how the consultation process will add
So that's
strength
why-
to the whole deliberations both in Parliament and outside. I suppose, therefore, what is one concern is that when the Parliament is likely to get into this job, will, for any reason, the court will kind of orient a parliamentary debate or a public consultation? May not. May not.
Because
That's one
you see,
one concern.
the hearing is happening not now.
Might have.
It was happening
In several-
sometime in September, perhaps, when such an assurance was forthcoming. Mr. Mehta was there,
It
and but as yet we are at this
Lordship
stage
knows
of
the deep dimensions of a debate like this.
we are not looking into their functioning.
Yeah.
The legislature would have its own way of functioning. But
Lord,
as a court, what are we?
Lord, your lordship's concern, my lord, is, my lord, I bow down to that, my lord. My instructions are specific, my lord. The Parliament session has started from yesterday. It's in two phases. The second phase would start from 13th of March. My instructions are that subject to the bill getting approval from the cabinet, my lord, it has to be routed through cabinet. It is intended to be presented in the second half of this session. My lord, that is between 13th of March to 6th of April. These are my instructions, and I have said so on affidavit also. There, my lord, we have not said the second half part. We say we intend to my lord, introduce, but I took instructions, my lord, day before. Yesterday also, my lord, I had a discussion with the Honorable Minister. He said we can't say what the cabinet will do, but subject to that route, we are ready and we would introduce it in the second half of this.
This is a short session, my lord. There's only 1 week.
This is
So
for
that's
on
why
the budget, my lord.
yes, only for the president's address of the budget, my lord, and thereafter.
Bills would necessarily
Be
come
in
in
the
the
next session.
next leg of this session.
Yes.
It can't be introduced in this session. That's Mr. Sibbal has the experience of the other side as well. Except,
No, Manas, your lordship is absolutely right.
so therefore,
I tell
we
you,
are saying that between the
no,
up and
Manas, the way even when the bill is introduced, Manas, in the second half of this session, Manas, it may go to the consultative committee or the standing committee. And that takes another 2-3 months. So that is there, Malas. That means it can stand over. Ultimately, it will become law definitely by July. This is my, if it doesn't go to the committee, Malas, it will become law immediately. If it goes, it will become law by July. That's the timeline, honestly, that I can give to your lordship. Nothing more than that.
And we can't assure what would happen on the floor of the house.
That's right.
Whether it would be passed, it would be.
No, that
I
majorities
thought-
are there. We are all in support of
No, not it would be. I'm sorry, my lord, my learned friend.
The bill itself,
My learned friend took it, my lord, purposefully wrongly. I didn't say it would not pass. It would pass numerically, but it might be referred, etc.
That's what I said. I said that.
That's all.
That's what it is.
So
And,
from the experienced parliamentarian, we are getting a target of July.
Definitely.
So what Mr. Diwan is saying that, this timeline of next session of the parliament, how far that will have a repercussion, that's something we have to consider.
Whereas my request to your lordships is the following, Malas. Even if your lordships were to actually hear the matter, we are not objecting to it. Even if your lordships were to hear the matter, what will happen? By the time the judgment comes, Malas, the bill will have either gone to the standing committee. Then, Malas, your lordships or judgment or passed. Your lordships' judgment will stand in the way, Malas, of the bill that has already been passed.
It might, the parliament may be benefited of the judicial view on this.
The problem
The
there,
parliament-
I'm sorry to say that the problem there is, I'm sorry.
Where
Normally, we wouldn't override, not normally.
No, I'm
We
saying
would
something
not
else.
override the parliament.
No, Malas, I'm saying something else. The problem there is that the nature of this legislation is such that it is not just an ordinary legislation. It has ramifications on investment. It has ramifications on freedom of speech. It has ramifications on privacy. It has ramifications on not just WhatsApp, because today the target is WhatsApp, but it will impact every other intermediary in the system. And that's why 9 distinguished judges of this court said, in matters of this nature, we should await Parliament to pass a legislation. And I will invite your lordship's attention.
That is a.
That's all that I'm
Of course.
Yes, therefore, mothers, what is going to happen between now and July, assuming that's the last date, it may pass in March itself, but assuming, mothers, it is between now and July, what's mothers? If at all, mothers. It took 6 years in the European Union to pass the bill. 6 years.
Maybe
one more thing.
maybe I was wrong in choice of my word that parliament will be benefited, but
Lord, one more thing.
yes.
Once Parliament passes a law, your lordship does sit in judicial review, and your lordship,
That's right.
Lord, obviously can. But your lordship's judicial review, your lordship's judicial pronouncement being debated in Parliament for acceptance or
That's
rejection
not right.
should always be avoided.
Yes.
Not that. Sometimes not laws are passed overriding any
Lord,
decree order.
Well, if your lordship renders a judgment earlier, what will happen? It will be debated.
it would be debated, but Lord, and the
Well, I would
purpose
not
is,
insist
Lord,
on
the
that.
purpose possibly, I'm not talking about the litigants, Lord, here.
We are not on all this
Lord,
debate. of
discuss the
parliament
bill
and-
and find out the inadequacies of the bill,
Yes.
criticize, etc.
We
It
would
should
go
be avoided,
into,
Lord,
we
why?
won't go into discussion over the bill.
No, but
But the
necessarily,
issues
Malad,
issues
issues
will-
are exactly the same.
And
Issues
the
with it.
irony is,
Privacy, consent, they're all the same.
my Lord,
Malad.
irony is, as I said yesterday, I'm supporting the users, namely Mr. Diwan and the, my Lord, the side he represents. If the bill comes into effect, it is the intermediaries who will have to challenge it.
My learned seems to be very sure about that.
Then
Your geographical position is not correct.
No, that's correct. Malad.
That's what I said.
We don't know, that's a very good speculation.
Yes.
But quite frankly, Malad, I have not contradicted him even once. I personally know, Malad, that in fact, when the bill comes, it will support our position. That's what I think. Maybe my learned friend
Anyway, there's
hasn't.
nothing to challenge that.
We can't speculate.
But be that as it may. This is our submission, Malad.
May I just make a few points on the nature of recapitulation, just one or two.
I just want to add one thing before he starts.
You are
I'm for Metamor, I'm for the main holding company. I just want to mention that there is no Vishaka situation. There are regulations in place now. Already, so the regulations are there.
We said it
There is a
yesterday.
grievance redressal mechanism. There is an officer whom you can complain to. These people have not made a single complaint to anybody and they're challenging everything in the air. So it's not as if the people are helpless. This is a complete 2011 regulation with a complaint mechanism, grievance redressal officer. So it's not like Vishaka where the law is crying, it's a complete vacuum or people's human rights are being trampled over.
Only one more addition, Manoj, before
And Lordship,
Mr. Diwan.
just as we don't discuss sub judice, once it is before the legislature, what will happen is your Lordship judgment is Article 141, binding. Some legislature comes. Now, they should not be that your Lordship holds A plus B is equal to C, and then the Parliament says A plus B is equal to D in advance. That may lead to a slightly awkward position, if I may use a term.
Constitutionally awkward. Another aspect.
Just say one thing. These are discussions or debates in relation where there is no specific complaints we are dealing with. As I said, there is a 2011 regulation. That regulation is holding the field. Maybe adequate, maybe inadequate is one thing. But that's not a ground, to strike it out and then do what? The second one is on the anvil. The second one is on the anvil. The first one is not challenged. The statutory regulations are of 2011. They are not under challenge. These are, these are kind of allegations. If this happens, that happens. There's nothing concrete really speaking.
Yes.
So that
One addition, Manoj, one addition.
nothing, specific. Unless there is something specific, if it has waited, for so much time, another 2 or 3 or 4 months can't really make a difference.
In fact, not the.
And have this clash between the legislature, doing one way, court doing another way, just because 2, 3, 4 months are in the interregnum.
Not in fact, the question
matter
that they
of 3,
framed,
4
sorry,
months.
sorry, sir. But in fact, the question that was framed by them for your Lordship's consideration was whether the state should act to bring in a legislation or rules. Now, that's what's happened. That's in fact the question framed, which is at page 778 and 7789 of the convenience compilation. That is what they wanted. Now there is a law. Now, how can they now go beyond that?
Don't wait for the intermediary.
One have a word in. I think he's waiting anxious.
Certainly, certainly.
Only one addition, Manoj. In one of the matters, Manoj, the regulations are also in question. Now the new regime, which is yet to come, Manoj, takes a different view of the regulations.
Yes.
That
That
is,
is correct.
I must note the point.
That is also true.
Why don't you voluntarily undertake the intermediaries? What is coming?
They should, Manoj. They should.
Yes.
That's our case, Manoj. They should.
Manoj, yeah, we are not standing in the way, Manoj.
We are saying that you have your own code.
Yes, we are compliant.
Whatever is coming.
Hey, whatever you are doing in other countries,
Yes.
you cannot discriminate India. That's Manoj the stand of that.
Manoj, hold on. Manoj, that's one. There are two global regimes.
Yes.
One is US.
One is the US and the rest of the world.
So Europe and rest of the world.
Yes, that's what I'm saying.
Correct.
Then Europe. So Manoj, they are saying you follow the European regime. We are saying you follow the other regime. Now that's a matter that the law will decide.
What is the proposal?
Manoj, if the,
European regime of the-
no, not the
Indian
Euro-
regime, Manoj, which
not the European
protects
regime.
the privacy and Manoj,
Because
everything.
we have possibly
our-
have maximum number of subscribers.
600 million.
Yes.
600 million, Manoj.
No
Manoj,
intermediary can ignore
the
India.
proposed legislation considers both the European as well as the global
And then
regime.
takes a view.
And then takes a view.
Yeah.
Concerns
Therefore,
Europe.
that-
Our legislation should be the bellwether.
Yes, absolutely.
therefore-
Because
therefore-
we are serving 600 million people. It has to be. It should be.
Intermediaries, Manoj, cannot ignore Indian users.
Absolutely. No, we are not.
Commercially, they cannot ignore.
We will not. We will not. No
In fact,
question.
on behalf of Twitter, I'm appearing for Twitter minutes in one of the petitions. Our affidavit indicates how the proposed legislation takes care of the grievances. So there's no question of intermediaries necessarily being adversarial to this
Whatever
legislation.
is the proposed legislation,
Lordship, please.
are you complying voluntarily with the requirement?
It's under debate, Malad. How can
We
we-
are
This is public
conducting
discussion.
take Care of all this.
No, then I can understand the central government's stand that Parliament is insisting over or is going to be insisting over the matter. But why are you kind of?
We are complying with the law. Look, there's a 2011 regulation. We are complying with it. We're compliant with it.
That is not a challenge.
But no.
In one petition,
In one petition, it's under challenge.
otherwise there is no challenge.
Otherwise, no challenge.
And
there is no stay.
There is no stay.
Not the regulations are in force, they require a
Malad,
privacy
If
policy.
you
We
still
have that
want
in
to hear
place.
it, Malad, we
We're
don't
already
stand in the
under
way,
that.
quite frankly.
We are not going to.
Malad, we won't stand in the way still now. We have just put our points of view before your lordship. Beyond this, we will not.
Your lordships can consider, your lordship sees the anxiety of the private operators. The
No,
government.
no, no.
What is all this?
There's no anxiety.
Yes, import, your lordship,
I hear it, but we
we have
don't show that we are
been
running against it.
saying that the 2021 policy, which will not collect large metadata, doesn't give an opt-out option, which they gave in the 2016 policy. Let them give us the opt-out option, to opt out of the fact that they will not share data.
WhatsApp.
They are all opting out of sharing the data. They want this situation, unregulated situation, to continue, so that they will not market the data. We have filed interim applications.
Does a proposed bill deal with that?
Yes,
Of course.
yes.
Of course.
It does.
It could be complained.
Malad, in fact, the proposed bill says,
Sorry, Malad, the present regulations also
Give you sort of
It deals with that.
it deals with it. Even the present regulations deal with it.
But that's what I confess.
They deal with it. Malad, they say, if you do not consent, you can opt out of the system. That's what it says.
means is what? Just a moment.
Malad, this is-
will not go anywhere.
This
Let
is
us
what
see the present
Malad,
regulation.
quite frankly, please hear the matter, Malad. I don't want to.
Let us see the regulation.
Please hear the matter, Malad. We are not standing in the way at all.
I
We are
consciously
suggested,
said-
Malad, let's hear the matter.
See the regulation.
But I consciously said, when the bill comes, the intermediaries will challenge it. I said that conscious.
Please look at 72A of the Act. Your lordship will get the answer of the current legislation.
Where is the regulation? Let us just have a. look.
Regulation is-
Sort of, how much of time is being taken in all this preliminary round that we don't get a.
This is your affidavit.
Now that Mr. Sibbal and Mr. Tata, I both heard them say, let us proceed with the merits, let us proceed.
Yeah,
with
you
the
want to
merits.
proceed, Malad,
We
I
have
have
said to
we
proceed
have
with
no
the merits.
problem.
Let us proceed with the merits.
On behalf of Brother Ajay, I would like to flag a personal logistical issue. I just did a small little calculation. We have exactly 107 days till May 19th. So 18th of June, Ajay will pick off. Yeah, that's a logistic, it's been to the heart of the problem because when you hear it, it's going to.
Yeah, take time.
Not going to take all that much.
It's going to take a lot of time.
Lot of time.
No.
So
You say the anxiety that is being projected is not from the bar side, it's from the bench side.
We have not
So
projected.
don't make a comment on that.
We are aware of it, but we have not said anything.
And
So that it looks, doesn't look nice for a lawyer to say that the bench will not be available. We never said.
your lordship's judgment would be quoted across all jurisdictions. So we will also assist your lordship.
So let's have a look at this preliminary, let's see the regulation.
Let's see 43A first, Malad.
This is the information technology, what are the?
Yes, the Information Technology Act 2000, Malad.
But see section
Section
43A,
43A and then the
that's the
regulation.
power to make regulation and then
All right.
Mr. Sibbal will show you the regulation. 43A.
43A. First,
Yes, we got it.
This itself came by an amendment.
yes. Let's kindly see 43A was inserted by an amendment act of 2008 and came into effect on 27th of October 2009, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. For the purposes of this section, body corporate means, your lordships may leave that out. Reasonable security practices and procedures means security practices and procedures designed to protect such information from unauthorized access, damage, use, modification, disclosure or impairment, or may be specified in an agreement between the parties as